lockup.
He's unable to discuss the potential of waiving his presence in the courtroom. He's shaking, he's twitching, he's mumbling, and he said he is about to explode and he doesn't want to hurt anyone.
Okay. He made some comments to Court Officer Gator that we should put on the record before I make a decision here. Why don't we just have swear Officer Gator, if we could, please.
You solemnly swear that the testimony you're about to give in the cause now and hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Court Officer Gator, what is it that the defendant said to you?
I thought we were about to begin, Your Honor. I asked Officer Lang, are you ready? He informed me that Philip Chism would not come out. At that point, I went inside, asked Philip what the problem was. He said, I can't take this anymore. I can't come out. I can't take it. I don't want to hurt you. I don't want to hurt anyone.
Well, my concern, quite frankly, Ms. Regan, is we obviously have been down this road before. I've read through the competency evaluation with some care, and it was clear to me from that evaluation that the defendant was competent. It was clear to me from that evaluation he was competent at the time that he was sent for the 15A, and that his conduct at that time, based on what I read, was rather a refusal as opposed to an inability to consult with counsel and to understand the nature of the charges. And my concern is that the situation is no different here. Defendant can waive his right to be present. Of course, the problem with that is that he needs to be competent to waive his right to be present. And of course, he can waive his right to be present after a full colloquy. One thought I have before, and I'll hear from the Commonwealth as well, is assuming I can make the Waller findings and the Sixth Amendment public trial Waller rights are not contested, I could speak with counsel present and observe the defendant outside of the courtroom before making a decision on a 15A. Because it's been my observation since the trial began that the defendant appeared no differently than he did at the motion to suppress that went on for a number of days. He appeared no different than he did through the protracted impanelment process. And there's nothing before me to suggest anything other than this is a similar situation than as what happened before, as it relates to competency, which is a refusal as opposed to an ability to participate. So I'll hear from you on that, and then I'll hear from the Commonwealth.
Dr. Barrett in 15B did consider the possibility that the stress of the trial would become too much for Mr. Chism. And that may be what's happening now. I'd also point out that while he was at Worcester State Hospital on the 15B, his treating psychiatrist diagnosed him with a psychotic disorder and put him on antipsychotic medication. So it's not that Philip is without his challenges. So given that he's a 16-year-old, a juvenile being tried in Superior Court, he's not an adult. This is a very stressful situation. and he does have this diagnosis of this serious mental illness. I'd urge the court to have the 15A just to be sure, because the court has to make a finding of competency, and these are reasons to doubt his competency to waive his presence. So I'd suggest that it is imperative on the court, in order to fully address the issue of his competency to waive his presence, to have the assistance of the court clinic in a 15B.
Okay, thank you. Ms. McDougal, is this heard?
Just very briefly, Your Honor, obviously the Commonwealth shares the court's concerns about what's happening here. I would note the timing, that this is happening on the eve of what I think was apparent to everyone was the recycling barrel being brought into the courtroom. I'm sure it is stressful. I think it's stressful for any defendant facing a murder charge. The last couple of days, the defendant has been made acutely aware of the bulk of the evidence against him. And I am very concerned about the timing of this. Frankly, this has been one of the Commonwealth's concerns. We did have a motion prepared, as the court can see, some weeks ago on this issue of waiver. And I would ask, certainly, that the court, at a minimum, make observations and inquiry on its own. I think that the defense carefully picks and chooses what it chooses to highlight from that competency report. And as the court is well aware, the balance of that competency report, and I think it goes very far to call it a diagnosis at Worcester State. And frankly, I didn't think it was appropriate in the opening statements, but chose not to address it yesterday to say it as it was said. I think that is a very small piece of the competency report. One of the things the competency report talks about is treating the defendant in a way that is in no way harsh, but that is firm. That makes clear to him that he is not in charge of this process. And I'm concerned that right now he thinks he is. And it was a difficult morning. Frankly, his statements to Mr. Gaeta, obviously I'm given great pause by any suggestion he's going to hurt court staff, and I don't want to minimize that. I'm sure he can't take it anymore. I'm sure it's very difficult to sit here and listen to that. I frankly don't think there's anything irrational about that.
Well, that's my concern, Ms. Regan, and I'm not saying I won't do a truncated, at least 15A, have Dr. Parada if she's in the building, take a look at the previous reports and observe him. I'm not saying I won't do that, but I don't have anything before me other than a defendant who has appeared every moment since this trial began, and every moment that he's been in court, including previous motions, to be competent. And my concern is that he is very stressed, as anyone would be, never mind a 16-year-old, and that the reason he doesn't want to come out is because he's stressed. That's not competency. That's a refusal. And while I will admit I'm inclined to do the cautious thing, which is at least have Dr. Parada read the report and observe him, at this point in time, I don't have anything before me to stop this trial to go down that road. And therefore, assuming I can make the Waller findings, I assume that the defendant doesn't want the press accompanying counsel into lockup, but assuming I can make the findings, that I at least observe him myself. So is there any objection to that on Sixth Amendment grounds?
No, Your Honor.
Okay. On First Amendment grounds, having looked at the Waller findings and based upon security issues and the closure being no broader than necessary to protect the interests involved, that the court believes that the interaction with the defendant outside of the court is necessary. The court will reduce its Waller findings under the First Amendment to writing as soon as possible, and we'll take a recess so that I'll be able to observe the defendant before making a decision relative to 15A. I'm going consult with the court officers and then with the government and defense counsel observe the defendant in lockup. All right, court will be in a short recess.
All rise. Court will be in a brief recess.